Okay, so hello everybody. My name is Stephanie Johnson. I'm the managing attorney at the Tallahassee Office of Legal Services in North Florida. And welcome to our training on expunction and sealing of juvenile criminal arrest records. I'm going to use the words expunction and expungement intermittently because expunction is really hard to say. So, but that's what the statute says. So we are doing this training in conjunction with a new project that Legal Services is starting called the Square One Clean Records Project. And we started this project because we noticed that a lot of youth that were aging out of foster care with delinquency records or criminal records, they didn't know what to put on job applications or housing applications as far as the record is concerned. They didn't know if they were qualified to get an expungement, and they didn't know whether their charge or conviction was one that would automatically come off their records at a certain point. They didn't even know what their disposition was, actually. So what we wanted to do is we wanted to pair these youth and the young adults in the independent living programs with an attorney, so that attorney can provide them a consultation and look at their criminal record, look at their delinquency record, and if an expunction is appropriate, even file an expunction for them. And so that's why we're having this training. What you're going to hear, let me just tell you the nuts and bolts of the project. Thankfully, we have several attorneys who are interested in becoming pro bono attorneys on this project. And kind of the nuts and bolts of how it's going to work is we're going to get a referral from Children's Home Society. They're going to refer the child to Legal Services. Legal Services will then get the guardian ad litem program to submit an order to the court to release their phase sheet to us. At that point, we will connect the pro bono attorney with the independent living specialist, which is basically the child's caseworker. And so that independent living specialist will call the attorney, schedule an appointment, and the independent living specialist will transport the child either to the attorney's office or to Legal Services or wherever you decide to meet. And then finally, Judge Scherstrom, who is the dependency attorney, he will make sure that all this has been done, and he will advise, or he will tell the child how important it is to go through this process at the next judicial hearing that the child has. So what you're going to hear in this training is a lot of legalities on how to expunge a record and record sealing. And what we hope you'll also be able to do is talk to the child, the young adult, about the realities. We can tell kids that if a job application asks if you've been convicted of a crime, you can deny it because you were adjudicated of a delinquency. We can tell kids that if they get an expunction, no one is supposed to be able to see the record. We can tell kids that it's illegal for an employer to ask them if they've been arrested. But unfortunately, that's not the reality. And usually the reality is what prevents them from getting the job. So they're really going to be asked about arrests. I mean, it just happens. Employers ask them. Sometimes the clerk may have not swept their entire record clean. And frankly, the employer is not going to care about the semantic differences between the words crime and delinquency. So they just see a dishonest kid who didn't admit to a conviction. I was talking to an employment lawyer last week about this frustration between the law and what the reality is. And he suggested that if you're going to be advising a young adult and maybe telling them that at 25, this is going to come off your record, to put that advice in writing on your letterhead, because then if the child gets called on it by an employer, they can just show them the advice letter and say, no, I'm not being dishonest. This is what the lawyer told me, is supposed to happen. So we're going to work with that and see if that works. So one more thing before I introduce our trainer. I have been working with foster youth and kids who have transitioned out of foster care for 20 years. And these are extremely resilient kids. And it is very rare that an adult takes time and tries to help them. It's a huge thing for them. So as you're sitting with them and you're looking at the mistakes that they've made on their face sheet, we hope that you use this as an opportunity to connect to the child. And, it could be as little as calling them 2 weeks later and saying, hey, do you have any more questions about what we talked about the other day? Or asking them, you know, give me a call when you get a job, I'd love to hear about it. I mean, any connection that these foster youth make with an adult is a huge thing for them. So we hope that that works out too. So now let me introduce you to Nancy Daniels, a person who has gone above and beyond in making connections with foster youth and youth and delinquency systems. She was the public defender for the 2nd Judicial Circuit for about 26 years, and she's currently a legislative consultant for the Florida Public Defenders Association. She has always fiercely advocated for systemic improvements for at-risk youth, and she has very graciously agreed to be a resource for this project. So, Nancy?
Well, thank you, and welcome everyone, and thank you for participating in this project. It's the rare foster child who is able to successfully navigate this post-18 world. So few are able to go forward and graduate from college and really make it too many steps beyond, and they have so many disadvantages. So this project is great for trying to give them some help and help in any way that we can legally or other ways if we get from a relationship with a child. I want to give a very clear theme to this presentation, and that is it's going to be the rare case that you ever use the one-time remedy of sealing or expunction for a child. It's going to be rare for a number of reasons. Generally speaking, the records are confidential. Juvenile records are confidential. Court clerks do not disclose juvenile records. Florida Department of Law Enforcement discloses felony arrests, but not misdemeanors. So that's one piece of this puzzle. Another is that juvenile records automatically by law are administratively sealed at certain ages. So most kids are going to have their records automatically administratively sealed at age 21. If they're more deep in serious kids who were considered to be serious habitual offenders or went to a juvenile commitment program, it'll be age 26 when it is cleared. But we're going to go through all this, but I want to start with the theme that for one reason or another, either because other remedies are going to be in place to seal these records eventually, and because expunction and sealing is a one-time only remedy that the state gives you, it's going to take some ferreting out to find a case where it is the right thing to do to use that one-time tool. Now, there are going to be cases, so we're going to go through some details here and try to come up with a methodology for how we figure this out. But just start with the proposition that usually you're not going to go through this whole expungement ordeal, because that's really what it is. It's very complicated and expensive and time consuming, and it's a bit daunting. So luckily, other processes are going to do that work for you sooner or later. Just to go through the Expungement Statute, it's probably one of the most poorly written and complicated statutes you've ever read. I've probably read it, I don't know, 100 times in my life, maybe more, and I still see things in it and go, what? And you have to read all these other statutes that go along with it because except as provided in 943 blah, 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 and only the list of crimes in 943 blah, blah, blah are eligible, and it's just quite an exercise to go through this. But expungement itself is only for case charges that have been dismissed or found not guilty or non-prossed by the state. So if a charge wasn't filed after an arrest, or if the person went to trial and was found not guilty, or if a judge entered a dismissal for some reason, or entered a judgment of acquittal, and that case went bye-bye, then they might be eligible for expungement. However, many enumerated charges are not eligible for expungement or sealing. And those would be the more serious offenses: murder, sexual offenses, domestic batteries and assaults, any kind of aggravated assault or battery, felony battery, burglary of a dwelling, carjacking, kidnapping. If it sounds serious, it's not going to be eligible for expungement or sealing. Then there's another hurdle. Let's say the charge isn't that. Let's say it's a trespass or disorderly or something else that is eligible. Now you got to go, number 3 there, to their previous record. Have they ever been adjudicated guilty of any offense ever? And a lot of people have. If they have been in the system a bit, usually as a first offender, you'll get a withhold of adjudication. But if you're a second-time offender, you probably are going to pick up an adjudication, either as a delinquent or an adult criminal. So if you've ever been adjudicated guilty, you're not eligible for expungement. So as you start to see here, you have to do quite a bit of research into this person's record. You're going to have the face sheet, and it's informative, but you may need to do more digging beyond that. And most clients of any age are not accurate reporters of their own record. Most clients say, oh no, they dropped that, or no, they didn't do anything for me that. Well, when you look at it, 9 times out of 10, they entered some kind of a plea to it and they were either adjudicated guilty or maybe got a withhold and were placed on probation or did some kind of a sentence. But it's either because it's just so complicated and they have bad memories of it, or it's just ill understood. But you can't rely on what the client tells you. You really have to get the records yourself and look and see what they have. And then just, as Stephanie said, just calmly and supportively say, well, we've got this we have to deal with, or this, I'm sorry, this bumps you out of expungement, but maybe we can look at sealing, or, so just have to have a thorough understanding of the current and prior record. And so then number 4, and this is what I just have to keep emphasizing, if a charge has been filed and gone through court against a person and they are eligible, they've gotten through all these other hurdles, just remember they can only get one one expunged. So you look at somebody on one of these face sheets, we're going to see they have numerous arrests. So let's say there's a felony that's eligible. You're probably going to want to expunge the felony, not the misdemeanors, because a lot of subsequent questions are going to be, for housing particularly, have you ever been convicted or adjudicated of a felony? So you're going to have to do some discernment about what they have. Now, if we're dealing mostly with 18-year-olds that are just aging out of the foster system, I hate to say it this way, but they may not be done with their criminal career. This juvenile record does have some protection, so you may just look at it and say, this one's going to automatically go away at age 21 anyway. Let's not use expungement in case you ever have something else. We don't want you to have anything else. We're going to do everything in our power to help you steer away from anything else, but Let's not use this one chance. And just the last thing, let's say someone's arrested over a 1-year period, and this is not uncommon at all to get arrested day one for a burglary, and then get that disposed of, maybe go through a program or do something for that, and then not too long later get a grand theft or get a trespass or just get something else. You can only get one arrest, and there's a slight exception. Let's say you do a crime spree, you do 4 car burglaries on the same night, and it's all basically one bad night event, then you might be able to get that one arrest and directly related arrest expunged. But by and large, it's just one arrest. And there's some discretion. There's some case law in here. I'm not going to go through it too much detail, but courts aren't always just wild about doing expungements. So they have some discretion, and you might go through all these hurdles and make the decision to go forward, and then unless every single dot is done and all that, there's some discretion for the courts to deny it anyway. I don't think that's a big problem in this area because the state attorney's office, by and large, if you're eligible, you've gotten through all these hurdles, and you've gotten your certificate of eligibility from Florida Department of Law Enforcement, our state attorney here pretty much checks off on them. So they don't challenge them, and there's no court hearings. It's just done. The big hurdle is this procedural stuff we have to do. Here we go. Okay, so this is everything you have to do to get an expungement. Is a lot of stuff. Court clerks' offices have expungement packets. They're also available online on the Florida Department of Law Enforcement website. It's a lot of papers. First thing they have to do is get a fingerprint card done. So they have to go to a law enforcement agency. The bailiff's office and the courthouse will do this for people. The sheriff's office will do it for people. I don't know about TPD.
They won't do it anymore.
They won't? Okay. But you have to get somebody to, law enforcement, to do this fingerprint card for you, and then submit that with a $75 fee and an affidavit saying you're eligible and you've never been previously adjudicated for the offense and that type of stuff. You have to get the paperwork for your charge. You can't still be on probation for it. It has to be done. And then you have to submit all this stuff to the Florida Department of Law Enforcement. And then they do a national search to see if this person has ever gotten a crime that they haven't disclosed. And they find stuff too. They frequently turn these certificate of eligibilities down. And it takes, I put minimum of 90 days there. My experience lately is that it's 4 to 6 months. It's a long process. So you might ask, and please do ask if you have questions as we're going along here, please. Well, do they ever waive that $75? In statute, it says they will, they could, they might. I have never ever once known them to. I used to regularly call the general counsel and say, will you waive it for this guy who just graduated? No. No. I'll run it up the flagpole. No.
And we've also talked about, as part of this project, also doing a records release to see if they ever have waived it for anybody, because, you know, a former foster youth would be the ideal person to be able to get a waiver. So if we do have somebody who gets a case where it is actually going to an expungement, that's definitely something we can explore.
Yeah, and I'd love to rattle their cage on that, because it chills the whole process to have all this cost issue. So the mechanics of once you've gotten through all this is you actually file a petition. Once you get the certificate of eligibility, that's a happy day. I just, right before Christmas this year, Christmas Eve, my client came in and had got this in his hand, and it was like, wow, what a great Christmas present, because it's quite a thing to obtain. But then you actually file the petition, it's in the forms, in the rules of procedure. You serve the state attorney and the arresting agency, and the state attorney here has a person, Amy Lee, who handles that, and she will, as I said, if they have that certificate, she'll just sign the form and check off on it. I don't know in other parts of the state whether they are so nice, but usually there's no hearing. Once you submit that petition, it goes to the court to act on it. It's usually within a day or two if it's uncontested. So that part goes real fast. It's the certificate of eligibility that takes so long, but once you have it in hand, it's no more than a week before you have obtained an order of expungement, and that's distributed to all these, the state attorney, the arresting agency, the FBI, and it's actually obliterated. That's the difference between sealing and expungement. Expungement is obliterated except for FDLE. They keep it. Now, here's the part Stephanie alluded to. Can the petitioner now say that they were not arrested for that case? Yes. The law clearly states that they can, but it cannot be charged with perjury for doing so. But there are 8 exceptions in statute, and they are basically the federal government, if the person is applying for employment with a criminal justice agency, if they're trying to be a lawyer, they're applying with the Florida Bar, they have to disclose everything. If they are trying to work for DCF or other state agencies, they must disclose. If they're trying to be licensed as an insurance agent, they have to disclose. And if they're trying to be a guardian, they have to disclose. I just came across one of those, and this is somebody who had a long ago offense, and she had to disclose it, and she wasn't allowed to be a guardian of the president, and it was just broke my heart. The basic private entities cannot have access to it. So they will get, a lot of places go to FDLE and get the person's rep sheet, and it won't be on there if it's expunged. So how do employers find out anyway? They do sometimes, because a lot of them subscribe to mugshot services. And this is just a totally separate entity than FDLE. So they may randomly figure out that the person really does have an arrest in their past. And I've had it happen, and I think we all have who've worked with this, that they say, okay, well, you're not getting a job with us. Or we've even had clients that had a job by now, and then that catches up with them and they get fired because they say, you didn't tell us about this. Well, my lawyer told me I didn't have to. The law says I'm clean on that one. I don't care what it says. And I've had many a conversation with general counsel of Home Depot or Lowe's or Winn-Dixie or all these different places that seem to find expunged records somehow. So it can happen, but I still think the proper advice for the client is, no, you've not, especially if it's just a juvenile record, that's not a crime, for one thing. And even if it's a juvenile record and it's been expunged, you have used a process of law that allows you to say no. So I know it seems squishy, but that's what the law says. And the case law is very, very clear on this too. So there are some exceptions to having to go through all this stuff. Recently, we've all heard the stand your ground law is law in Florida, and a lot of people are super interested in the self-defense exception. And so if a person either has been arrested, but then not charged because it's concluded by the state attorney that it was lawful self-defense, or they've gone through and had the case dismissed because of this, or been found not guilty because of lawful self-defense, they're eligible for this expungement, but they still have to get that certificate of eligibility and go through that $75 and all that, the 6-month wait and all that business. So it's not that great. I mean, I think it's throwing a bone to self-defense fanatics, but that's there. Now, F has been on the books for a while. Chris, you might have you ever worked with it?
We have not done one, we've explored it, but then, you know, sort of the person we were gonna do it for sort of moved on and left the area, but
Yeah.
we got, you know, maybe halfway through.
Yeah, for those that can't hear, there's a lawyer here who works with a lot of human trafficking victims, and it's hard to find somebody who's gonna be just quite eligible and present in your caseload long enough to have this. But the big thing with it is, how do you know they were a human trafficking victim? Who says so? You have to get some kind of documentation of the victim status, and the law is not too clear on what that is. I'm assuming that if a state attorney dropped a case or gave a lesser plea because of this, they would vouch for the fact that this was a victim and be willing to give documentation, but this is not very well filled in just yet. So if this one happens to come along, you may break new ground, you know, in using it. The one that is going to apply quite a bit to our folks is G, Teen Diversion Program Expunction. And this, if let's say the typical teen goes through a program for petty theft or for trespass, and they get a juvenile arrest, they go through an expungement program, they are eligible for this, and they just have to pay that fee, and it doesn't count for this once in a lifetime expungement limit. So that's a good one to look at, and on your face sheet, you're going to see some diversion programs where the clients may be eligible. Yes?
Just because this diversion program has come up under Marjorie Stoneman Douglas quite a bit, and they're now considered quite controversial, I'm just wondering if there's a definition of non-judicial diversion programs. My understanding is that there's 3 school districts that offer diversion programs, soon to be 2, and everyone else goes through the state attorney local diversion program. So what would a non-judicial diversion program be?
Okay. The question is, what's the difference between a non-judicial diversion program and a judicial diversion program? Drug court would be a good example of a judicial diversion program. It's a diversion from the regular court system, but it's still under the jurisdiction of the court, and it ends up in a court dismissal. That would not be a non-judicial diversion program. On the other hand, the state attorney's program, where they don't see the inside of a courtroom, they may see the courtroom the first day of their arraignment, but then they're shunted off to Deborah Shaw and diversion folks, and they go through the Urban League program or the Teen Court program or this one or that one. And that one is a non-judicial because the court isn't administering that. They're helping navigate somebody to it, but they're not exercising control over it.
Thank you,
Yeah.
very helpful.
So, and that one definitely is going to come into play for our folks. I think that's a biggie. So that's expungement, and just this case law is basically, it's an abuse of discretion standard if you ever got to the point of having an appeal on one of these. As I said, hearings are rare if someone goes through the regular process and is eligible and gets a certificate. So that's expungement. Sealing is almost identical, except that it is dealing with charges where there was a charge, there was an arrest, and there was a charge, and then there was a court process, and the person received an adjudication withheld. So that can happen either through a plea bargain, or it can happen through going through a trial and being found guilty, but the judge giving you the break of a withhold in your sentencing. So if it's a withhold of adjudication, it's eligible for sealing. However, it's that same list of enumerated charges are ineligible. So serious charges, murders, sexual batteries, carjackings, kidnappings, not eligible for sealing or expungement. Again, this one is the same. You're not eligible if you've ever previously been adjudicated guilty of any charge or delinquent charge, and you can only get one of these in a lifetime. And it's the same, you can only get one, but if it's a crime spree, you can get the whole deal sealed, and there's discretion of the court, but you're entitled to a hearing if the state attorney isn't going to agree to it, and the court has to comply with law and can't just arbitrarily deny it if you're eligible. So that's going to be more often the case because most of our clients probably will have gone through court on their case, and unless it's a very minor juvenile early entry case, and they might still be eligible if they got a withhold. And this is the same procedure, the fee, the certificate, and all the same stuff. And it's the same effect too. The effect is that the court seals it, they don't obliterate it, but it can't be seen by the public, and it can be denied except to the statutory entities that I just said, military, the bar, DCF, criminal justice agencies, etc. And you can't be cited for perjury for saying that. So case law is the same, there's discretion, and judges who just deny it arbitrarily can be reversed. So this is some newly breaking ground here is administrative expungements. So this is a separate legal remedy other than what complicated stuff we just looked at. The first one there might apply to some of our folks. If there's a mistaken arrest or an unlawful arrest, and the state attorney is going to say so, or the law enforcement agency that made this bad arrest, how likely is that? I think it's more likely the state attorney is going to say it's a bum arrest. You can pursue this mistaken arrest expungement, but you're going to have a piece of paper from the state attorney saying that. And I think that's going to be rare, but you know, it may be worth trying. This new one is so exciting. I was present at the scene when House Bill 7125 passed this last session. It's a mega criminal justice reform bill. It is 389 pages long, and embedded in it is this. Now, here's a little glitchy thing. That law, 7125, is not effective until October 1st of this year, but this exception, an expunction automatic deal here, is already in the statute book. So I think we're gonna be on safer ground pursuing it after October 1st. It's only another month. So that's when we're gonna shoot for getting this project going. So we're probably on firm ground there, but anything between now and then. This is great. This requires FDLE to administratively seal all records of adults and juveniles if either a charge wasn't filed, the charge was a null pros by the state attorney, a not guilty was rendered, or an acquittal was rendered by a judge, except for forcible felonies. So remember, we went through that saying there's already an expungement when a charge isn't filed and we're null pros and all that, but there's some exceptions. There's all those statutory exceptions to that. This only carves out forcible felonies, and forcible felony is a very interesting list in the statute. The first forcible felony is treason. But then there's some ones you would imagine would be on there: murder, sexual battery, carjacking, home invasion, robberies, bomb offenses. And then there's a catch-all, any other offense involving the threat or violence. So for low-level stuff, this is great. If it's gonna catch a lot of stuff that juveniles have happen, because they could go through, going back to the question about the difference between a judicial and a non-judicial diversion program, any way the charge got dismissed, they're gonna be eligible for this, unless it's a forcible felony or a sexual offense. So this is a great thing. It's gonna help some people, and they don't have to wait till they're 21 or 26 or any of that. This is just gonna happen as of October 1.
Can I ask, so being an administrative expunction, does anything have to happen to click that into place? It's just
Supposedly
supposed to
not.
automatically?
Supposedly not.
Okay.
I can't wait to see.
Yeah.
I'm gonna do some spot testing after October 1st and see what it looks like. But it is supposed to happen. I'm told that FDLE is gearing up big time for this. A question that's come up, and I'm just assuming it's retroactive. I mean, why bother just making this applicable to post-October 1 charges? I don't see why they would be gearing up and doing all that if they're not going back and doing all the past charges. But I hope there's not a problem on that. We might have to litigate somewhat if there's a way of doing that. But this is a great new thing. There's some recognition in the legislature now that we've gone overboard with all these records that people have, and no way to get it off in an easy way, and being stuck with it forever, ever, even if you got a good disposition of the case. So there's progress, and I'm really super happy to see it.
Is this limited to unlawful arrests and, or mistaken arrests?
No, it's any
So the
arrest.
first- But A is not a predicate to B.
No, they're two separate statutory exceptions.
Thank you.
And can I ask you, are you saying, so charges or arrests of adults that they commit the alleged offense when they're an adult?
Mhm.
If an information is not filed or if it gets dismissed, that gets administratively
Mhm.
sealed?
Unless it's a forcible felony or sexual
So
offense.
it could be domestic battery then,
Uh-huh.
or simple batteries or stalking, things like that.
Yep, if it's dismissed. I'm gonna go back and reread that and make sure that's the right answer. get back to you, but from what I see, yes. And the question is, would this include domestic batteries if they're not crossed or dismissed or found not guilty? Would they administratively seal under this statute? And I think the answer is yes. Question?
If they administratively seal, then what else would you ever have to file a request to seal for ever again? Because if seals only apply to these types of cases, and these are not going to be administratively sealed, what's left to file?
Well, it would be cases where they go through the court process and it doesn't result in a not guilty or a judgment of acquittal, and they get a withhold of adjudication. Those would still be eligible for sealing if they are not swept up by this. And that's going to be the majority of cases. The majority of arrests get filed and go through court and enter in, and there's plea bargaining and they're resolved with pleas. So, okay, but this is a good thing. And let's see, why did we go back wrong? Okay. So this is really the biggie that really was the theme I started with here. This administrative sealing in section 943.0515, if this was a low-level juvenile offender and they never got to the point of being classified as serious or habitual juvenile offender or were never committed to a juvenile program, they are going to have their record automatically cleared out at age 21. So if we're seeing somebody at age 18 and their juvenile record is confidential and they didn't commit a felony, there's no way that's going to be disclosed because the clerk won't disclose it and FDLE won't disclose it. They haven't committed a crime. I think the most difficult question is what Stephanie started with. Have you ever been arrested? The answer is really yes, but it's confidential. And it's a delinquency arrest, not a criminal arrest. So I always tell clients, let me see the exact wording of what you're answering on an employment application or a housing application. Read the exact words to me or send it to me so I can read it. I want to make sure we answer this as accurately as we can and not get you in trouble, but it clears out all the way at age 21. So, and then at age 26, if the person is a serious habitual offender or has gone to a juvenile program, then it automatically clears out at 26. And so are you going to see some people that have something on their record before they were 18? Yes. You might see people who have already reoffended after 18 or have now started getting a criminal record in addition to their juvenile record. So that's why it's just going to require such analysis to say, who's this in front of me? What do they have as a juvenile or hopefully not as an adult, but if they do? And what remedies are available to us or which ones are going to happen automatically? And then should we use this one-time expungement sealing opportunity on this person when there are so many other ways that it's confidential or it's about to be cleared out? So that's something that you just always have to have in your mind. I think I'm going to try to figure out a checklist of, okay, step 1, analyze eligibility. Step 2, analyze prior record eligibility. Step 3, analyze automatic remedies. 3, step, and just kind of decide what is that. Once we've taken all those out of the apple barrel, which ones are left that we will use expungement on because we need to to help the child, or the now early new adult.
Yeah, it's so fact specific. I mean, you can get somebody who at 18 picked up a misdemeanor, but that's the only charge they've ever gotten, and they want to go into nursing school or something. So for that person, it might be a good idea to pursue it because they, you know, you don't think they're going to commit any charge, and they really don't think, and that's the only way they can get their career started. So it's just going to be very fact specific.
Yeah, and I will say, as far as nursing degree applications and licensure, and even applying to nursing school, I've had a couple of those. And the nursing application, the nursing school application and licensing asks the question, have you ever been arrested and you must disclose any expunged or sealed offenses?
Wow.
They're very, very picky about it, and I had a client who didn't disclose a youthful shoplifting, and she had to go through a huge rigmarole to get through all that, because she didn't disclose it. So,
Why do they care?
I don't know,
Okay.
they're just, that's the,
I can't give you a shot if I happen to, you know.
when I was
Back it up.
17, I took a necklace, or, you know, I mean, I don't know, but, yeah, be real careful about any kind of licensure applications. But, yeah, this is, it's just, it is gonna be specific, and, this is called early expungement or expunction. If somebody between 18 and 20 does it, for some reason, it's called early expungement. It's referred that way in the literature. But just remember, it counts as a once-in-a-lifetime opportunity. So now that we've seen all this, let's look at some cases. Stephanie, you would help me with this because you've been over these face sheets. Has everyone here ever seen a juvenile face sheet, or is anybody? Okay, they're so hard to read. It's like reading an FDLE rap sheet. It's just terrible. It's hard, hard to figure out what it is.
Can it be any larger for aging guys?
Can we zoom that by any chance? Tech wizard lady?
Why is it called a face sheet? Like, what does that mean?
I was kind of wondering.
Yay, look at that.
Thank you.
Awesome.
Those aren't for looks.
Why is it called a face sheet?
Like, what is it? Is it one person or is it several people?
This is one person. This is 16-year-old female, we know. And I want to pretend that we're seeing her at age 18, after she's aging out, and this is her record. This just is everything she's got. So she starts with non-law violations there, and she's got a tampering. We see an intake, but we don't see any disposition date or adjudication there. Disposition unknown. That's,
Who
you would
prepares
have-
these? Like, where does this come from? Who?
DJJ produces this,
Okay.
Department of Juvenile Justice. And then let's just put a question mark on the 1/16/2018 arrest, because we don't know what happened to that. 2017 arrest there is robbery. Now, that should put red flags up. Uh-oh, not eligible because bad, serious offense, robbery. But it says on the right there, no adjudication and charge reduction. And we don't know what the charge reduction was to. Some robberies go down to petty theft or grand theft, but they might still be eligible for some kind of remedy. We're gonna have to get more records on that one. And even though court clerks don't disclose to the public, they do disclose to the child or the counsel for the child. So that's gonna require more digging. And then the rest of them we're seeing here, law violation, probation. We see an adjudication on that 10/7/2017 arrest, but we don't know what that's, the underlying case that they're on probation for. We see a petty theft, that might very well be eligible for something, but there was an adjudication. See the yes ADJ category there? There was an adjudication for that petty theft. So remember the rule, if you've ever been adjudicated guilty of a crime or a delinquency, you're not eligible for sealing or expungement. So this is a good example of how complicated this is.
And so, yeah, it's like, you're trying to figure out a puzzle. And my interpretation of the 10-7 charge that just went away.
Can you go back? Sorry. Thank you. Thank you.
So I think you need to go
Oh,
up
more.
a little, yeah.
So this one?
Is it the back?
No,
This one? There it is.
There you go.
All right.
So my interpretation of the 10-7 charge is it was originally charged as a robbery, and then that was reduced to a larceny petty theft, and that's the one that went to court, and that's the one where they got the adjudication. And that's just a guess, but that's, in reading face sheets over the years, that's my interpretation, probably what happened on that 10-7 matter. So yeah, reading these face sheets is like trying to figure out a puzzle, and it's quite fun.
Yeah, so if that theory is correct, and that's a good guess, the problem is the adjudication. So we're gonna have to sort through and see if any of these remedies apply despite the adjudication. So a Y in that column is always gonna be like, uh-oh, let's see what that is and see what's available here, if anything. Probably nothing.
But the Y could be a withhold, or is it?
No, the Y is
It's yes.
an adjudication.
Y means yes,
Yes.
adjudicated, right?
Yeah, so if you go down a little bit, Simone, on that same page, you'll actually see a withhold. Yeah, so the
Okay.
W is the withhold,
Yeah.
so.
And that bottom one there, you see the null pros. So that's a good one. That one, there's lots of remedies for cases that are null pros. But let's just say you say, oh, you got one that can be expunged. All right, a disorderly. Well, if you've got these other things that can't be expunged, do you want to use your expungement opportunity on a 14-year-old who got into a fight? If you think they're gonna maybe mess up more seriously down the line, maybe not. So that's why we're just always gonna have to figure out what do we have, what are the likelihoods here, and should we use this?
Well, under the new statute, since that was an all cross, that should go away administratively, right?
Mhm.
Should be administratively sealed theoretically. because
Yes.
it's an all cross.
It should, right. And it would go away, unless that robbery, let's assume it was reduced to something non-felony, that's gonna go away at age 21. All of this. So,
Is there a way to test that,
uh,
whether it went away or not?
well, yeah, the way is to get your rap sheet from FDLE and see what they're putting out.
So after they turn 21, it might be a good idea to advise them to get their FDLE record.
Right, and see if everything that was supposed to clear off did.
So FDLE is not supposed to disclose things that were juvenile,
Only
Over.
felonies,
only felonies.
right.
And is there a process if you check your rap sheet and indeed it has not been, there's a way to say, hey, wait,
Oh, it is so complicated to
Oh,
get something
yeah.
off that FDLE sheet, but yes, there is a process. It
Okay.
starts with calling their general counsel though and saying, hey, this is a mistake, I've got the records.
A couple of
Okay.
questions from our folks online.
Okay, we have some questions from the field here.
Okay, let's see. How do I get this thing on here? Oh, that's not it. Questions, here we go. Okay, so, okay, we got this one. After 10 years, will you be able to expunge under this new section?
Can't hear you.
It says, after 10 years, will we be able to expunge under this new section? That's the question.
Well, I think what that's referring to is you can seal some records for 10 years, and then if you don't reoffend within that 10 years, then you're eligible for an expungement. And then, so I think the answer is yes. If you use the sealing statute and you get sealed and you don't have any problems for 10 years, you can then expunge.
Our next question is, for DOE, educator applications require disclosure?
Yes, they do. DOE is one of the statutory entities that you have to disclose to.
Let's see. So this one.
That one is, does it take 90 days for FDLE? I said 90 in the outline, but my experience is it's more like 6 months.
Right now they're working on March.
Uh-huh.
Yeah.
Okay.
Okay. Let's see this one. Human trafficking. The understanding is that a juvenile is already considered a victim if involved in human or sex trafficking. Is that the case?
I'm gonna say I don't know the answer to that. Chris, we have somebody here. If the fact that a juvenile is involved in a human trafficking, are they automatically per se considered to be a victim?
Can you read the question again? I was not, I
Uh-huh.
was writing notes.
There was a slide and you discussed human trafficking victims having to get documentation of their victim status. My understanding is that a juvenile is already considered a victim if involved in human sex trafficking. Is that the case?
Steph, didn't we have to get a paper on a couple of kids that formally stated that they were the victims?
I'm gonna say in the room, we don't know the precise answer to that.
Familiar about that,
I would assume there's a presumption that any child
I think there is.
but the statute still says documentation.
Well, and I think if there's a court case ongoing against the abuser and the juvenile is a victim in that case, then clearly they're a victim of human trafficking.
But it gets a little complicated, right? Because so we've got a kid who was trafficked who got picked up on a stolen cell phone charge. Well, is that part of the trafficking or not? And so.
Right. Yeah, if you have an seemingly unrelated charge like stealing a cell phone or something that's not directly involved in the trafficking activities,
But yet,
does that get you out? Does that get you under this exception? I doubt it.
I think it depends on who the state attorney is. Chris and I were talking earlier that trying to link the crime with the trafficking is something you have to sort of advocate to the state attorney. And then, trying to prove that you actually are a victim of the trafficking is the second hurdle, or maybe the first hurdle. So.
Right. Since it's not a court order expungement or sealing, there's a question, but an administrative expunction, does it work differently? And no, it's not supposed to work any differently no matter what type of expunction it is, whether it's administrative or the rigmarole process that you pay for and go through all that paperwork for. Okay, I think we're just about to run out of time here. There's one more face sheet.
Yep, I think that's it for the questions as of right now.
Okay, let's see if we can get to this last face sheet.
Hold on, give me just a second. Okay.
All right. Okay, here's the second one. This too is a 15-year-old, but let's assume this is an 18-year-old and this is their whole history. Can you make that first part bigger? Thank you. The bottom part. Yeah, thank you. See, aggravated battery is one of the ineligible, on the ineligible list for both sealing and expungement. Intake, no disposition known, so hopefully maybe it was reduced or it's still ongoing maybe since it was just July. But that we'd have to see how the disposition comes out before we know. But the battery there, no adjudication, good. Went through a diversion program, good. So they may be eligible for a diversion expungement or a regular expungement, depending on the details. And then there's a 528-18 battery, closed, no adjudication, another diversion. So again, there may be possibilities of getting this one under that diversion expungement possibility.
Can I ask you, so if you've gotten diversions on both those charges, but then you actually commit an aggravated battery, that won't affect your ability to expunge the diversion?
Only if you're adjudicated guilty
If you're
on that.
Okay,
Right. But if you get out of that one with a withhold
okay.
or a dismissal, then yes, but you would definitely want to make sure what, you want to work like crazy if you're currently representing this person for aggravated battery to get it down so you can get that off of there and not have that knock you out of all these remedies. So that's pretty much it. And yes, question?
Yeah, I have two related questions, and I'm gonna euphemistically refer to it as the get out of jail free card. You've got one expungement, use it wisely.
Exactly.
So under the expungement, you say the petitioner may lawfully deny the arrest if it's been expunged. What if you choose not to expunge an arrest that appears relatively serious, but you're gonna save your get out of jail free card? You cannot deny the request, can you? I mean, the arrest.
No, if it's still on your arrest record.
You have to admit it.
Now, if it's a juvenile arrest, it's going to be confidential, and it's a delinquency arrest, it's not a criminal arrest. So again, the wording of what you're answering is the key to how to answer it. If it's, have you been convicted of a crime? No. Have you been arrested for a crime or for a criminal offense? No. If it's,
That's a no if it's a juvenile
yeah,
offense?
it's because it's not a criminal offense.
Okay.
It's a delinquency offense.
And then the related question, again, saving your get out of jail free card. If you had a relatively serious matter, would you ever use the sealed and then expungement, or just go straight to the expungement? Why would you go through a two-step process if you know you really need to expunge?
Yeah, well, if it's relatively serious, you gotta make sure you're eligible, because
Right.
most serious is, but let's say it's on the margin and it's not ineligible. Yeah, you have to figure out what's the worst thing on your record. I had, lots of my drug court clients had scattering of misdemeanor offenses or, minor stuff. Do we use the expungement on that drug possession felony arrest that was dismissed? Yes, because it's felony. So you do have to do some deciding about what's the worst looking thing. If it's felony, I think it's almost always going to be preferable to expunge that if you can, or seal it over a misdemeanor.
No, I understood that. I'm more to the concern, I guess, that let's assume you just have the one offense and you use your get out of jail free card now, or say, wait, I might commit a worse felony down the road, so I'm going to seal it, and then I have a 10-year window to figure out later what is my worst
Yeah,
offense.
that would be a wise strategy if you fear you're gonna reoffend. Most people don't think they will. Yeah.
Or get caught.
Yeah, right. That's right, I've never known anybody. Yes,
So you can seal one and expunge one?
well,
Or
you
is it
can,
one for
that
both?
same one. If you have sealed it for the 10-year period, then you can expunge it.
You can't expunge another one?
No.
A different one?
Okay.
Nope.
So if you
Unless
seal
it's not, it's one of those categories, it's not pros, dismissed, not guilty, but if you were adjudicated through court on it, no. I see,
So if you know, let's say you want to save, what, like he was saying, you're going to save your expungement, but if you were to seal the one that you have right now,
Mhm.
10 years from now, you haven't committed another offense, 15 years from now, let's say you have committed another offense, so you've got another one sitting out there, that one was withheld. Can you expunge either one or just the one that you sealed?
you can expunge either one.
Okay,
So you would make a decision, which one.
so
is-
theoretically, you can seal one and then later expunge a different one?
Yes.
Okay.
Yes. With drug offenses, I generally would talk to clients about, well, I think most employers are gonna understand if you say, look, when I was a kid, I was playing around with drugs a little bit and I did pick up a charge. Whereas if it's a burglary or even
Like sometimes it's
theft
honest
or,
act.
yeah, if it's something more with more mens rea, let's say, you're probably gonna wanna expunge or seal something other than a drug offense if you have something else. So anyway, I hope this wasn't too confusing. It is such complicated and murky and messy stuff, but I hope it doesn't deter you from participating in the project. I will be glad to help you with any that you get that are complicated, and I'm sure there'll be great resources. So thank you again for being here and listening on the webinar.
Thank you.
I hope we help some folks. And thank you.
Thank you.
Thank you. And for those of you who have expressed interest in helping with the project, John Fenno will be getting in touch with you. And if those of you who are now interested in trying to help, you can let John Fenno know, and we'll get you signed up. And yeah, we're gonna have a lot, it's a new project, so we're gonna have a lot of mentoring, a lot of assistance, and it's gonna be a good thing. Thank you.
Is John here now?
Yes, I think.
For a minute.
Are we done, Simone? Are we all?